Dennis O'Rourke.
Mr Speaker, this bill has been a long time coming since the government was first elected in 2008. Despite serious threats, nothing much happened until 2013, and then a rather ham-fisted attempt was made with some stopgap legislation. We had by then seen a situation in which agencies had acted illegally, in which nobody really seemed to know what the law was, and it was something of a shambles, presided over by a Prime Minister who was clearly not on top of his job. In fact, the best thing that came out of the 2013 legislation was the commitment for a comprehensive review, and the Cullen-Reddy review has been the result of that. And I want to take this opportunity immediately to compliment Sir Michael Cullen and Dame Patsy Reddy for an excellent and very comprehensive review, which forms the basis for this legislation. It's a comprehensive review, and most of its recommendations are to be implemented. New Zealand First takes the need for a robust regime to protect national security across a broad range of threats very seriously. And I was very interested to hear the comments made by Amy Adams and her description of the magnitude of cyber threats which are being mounted against this country on a daily basis. New Zealand First seeks better arrangements than we currently have to ensure the protection we need in a very troubled world, but not at the price of the freedoms and privacy that Kiwis are entitled to expect. We will support the bill to the Select Committee to pursue these dual objectives. The Cullen-Reddy Review's recommendations that the GCSB and the SIS and their oversight bodies be covered by a single comprehensive piece of legislation are the basis of the bill. It emphasises the need to remove the barriers to effective cooperation between those two agencies and the need to improve transparency and oversight arrangements to give the public greater confidence that the agencies are acting lawfully and appropriately. We support that approach. New Zealand First's objectives have always been, firstly, to protect Kiwis' civil liberties, freedoms and privacy, but also protection from threats to our safety and to our essential national security interests. Therefore, we fully recognise the need for effective intelligence, and we accept the need to conduct surveillance and collect intelligence about New Zealand citizens and residents where necessary, provided there is a robust process for authorisations, and provided the law is clear and effective, and provided that there are comprehensive review and oversight provisions to give the public confidence that the security agencies are independently supervised and accountable. I'd like to remind Kennedy Graham, I was interested in his speech, I'd like to remind him that the rights of every individual are subject to the rights of others, and those rights include the right of security. So the rights of individuals are not absolute, they are subject to the rights of others. And that's where I think the flaw in his argument is. Mr Speaker, New Zealand First has a number of issues that we want to pursue with this bill. One of the concerns is the membership of the Parliamentary Intelligence and Security Committee. There is a pretence still that there is a leader of the opposition, and that's archaic in an MMP Parliament. There is in fact no such office, and that has to be changed. That's in the bill. All of that has to be changed as far as we are concerned. This does not mean that as of right all political parties should be represented, but it does mean that representation needs to be more than just the old Labor national axis. The rationale is that the people on the committee must be experienced and trustworthy, and our main concern is that the committee must not be dominated by the government. Looking at the main elements in the bill, there will be a single authorisation regime which seems to me to be robust as set out. Warrants will authorise the agencies to carry out an otherwise unlawful activity where it contributes to specified objectives, and I think that's very important. Tier 1 warrants are required to collect intelligence about New Zealand citizens or residents, and approval for them is required by both the Attorney-General and a Commissioner of Intelligence warrants. Those two approvals, along with the oversight by the Inspector-General, are what is being referred to as the triple lock system, as mentioned by the Attorney-General in his speech. The activity authorised must contribute to New Zealand's national security, and that term, national security, is therefore very important. As we have heard other speakers say, there are two alternatives available, the one in the bill and that promoted by the officials. I prefer at this stage the officials' version over the one in the bill because it seems to me to be more focused and specific, listing relevant activities, and they were set out well by Mark Mitchell in his speech. I think that seems to me to be the better way to proceed. However, in the end, the Select Committee will need to consider and decide on that. The additional Section 57 criteria include a necessity test, as well as a proportionate to purpose test, and require that the purpose of the warrant could not be better achieved by other means, and there is also a requirement for reasonable use of the warrant and for the information collected to be used lawfully. So that's pretty comprehensive, I believe. Tier 2 warrants can be issued to collect intelligence about people who are neither citizens nor residents, and these are approved by the Attorney-General only, but otherwise the provisions are similar to the Tier 1 warrants. That all seems to be quite a good way to deal with the situation as far as New Zealand First is concerned. There is also a need for urgent oral warrants, and that's covered in sections 69 to 71, but that power is subject to the requirement for the Attorney-General to immediately advise the Chief Commissioner of Intelligence warrants, who can cancel it until a formal application is made. I'd like to say about Andrew Little's comments on that, that I don't agree with him that it's inappropriate for the Attorney-General to be able to be the person who authorises those warrants. I think that's quite appropriate, but what I would say is that I agree with Andrew Little when he questioned the length of time that those warrants can endure for, and we need to have a look at that in the Select Committee as well. Mr. Speaker, privacy issues are of the highest importance, and I'm very pleased to see that the bill increases the number of information privacy principles applying to the GCSB and the SIS in the bill. They'll give individuals an avenue for making complaints where none has previously existed. Of the greatest importance, Mr. Speaker, the bill improves oversight arrangements. The removal of the current restriction on the Inspector-General inquiring into operationally sensitive matters is good to see, and clarifying that the Inspector-General may review warrants on substantive as well as procedural grounds is a matter that New Zealand First has insisted upon during the consultation process. New Zealand First is pleased to see the Inspector-General's appointment will be by the House of Representatives. That will show that person's independence in that role. And the Inspector-General's functions in Section 121 provide a pretty comprehensive set of review powers, which I think will give New Zealanders great confidence that he will be effective in that role. He also has the ability to conduct unscheduled audits of procedures and compliance, and I'm glad to see that. There is also a complaints procedure of an independent nature to the Inspector-General, and that's good. Reporting is to the Minister, the responsible, the Prime Minister, the Director-General of the appropriate agency, and the Intelligence and Security Committee of Parliament, and that also is good to see. Now, Mr. Speaker, finally, it is good to see that the bill also offers some protection to whistleblowers and will bring the agencies within the ambit of the normal state sector arrangements. However, the restriction only to informing the Inspector-General is something that we will need to consider at the Select Committee. Whether that is satisfactory or whether there should be a wider ability for people to blow the whistle to other people is something that we need to look at. more closely. Finally, Mr Speaker, New Zealand First does welcome this bill as a work in progress, and we look forward to working on it at the
Called Jamie Lee Ross.